Welcome back, everybody. You're watching the Law and Crime Network this afternoon. I'm Aaron Keller. I'll be with you as we wait to see whether or not jurors in the George Burch first-degree intentional homicide case out of Green Bay, Wisconsin, will reach a verdict today. They got the case this afternoon after closing arguments from both sides, and we're waiting to see exactly how long they're going to deliberate today. This is a case where a defendant, who is a relative newcomer to the Green Bay, Wisconsin area, is facing first-degree intentional homicide charges related to the death of a 31-year-old young mother named Nicole Vanderheyden. The defendant is pointing the finger at that woman's boyfriend, saying that he believes the boyfriend is the real killer. We're listening to some of the defendant's testimony from yesterday on the witness stand. It was lengthy testimony, and it resulted in a rancorous cross-examination. We're going to continue to analyze that testimony in a little bit. In the meantime, I'd like to introduce Kendall Coffey. He's an attorney in the Miami, Florida area. Kendall, welcome back to Law and Crime.
Well, thanks for including me. Fascinating case.
It is. And, you know, let's just start off the bat here. It's one thing for a defendant to raise reasonable doubt. It's another thing for a defendant to have an entire theory of an alternate suspect. And that's what the defense has here. Usually in cases like this, there's a stronger chance for an acquittal because it gives the jury a lot more to chew on.
Yeah, and this isn't like the one-armed man, some mystery alternative to the guilt of the defendant. Here, and it's quite extraordinary, you've got both of the alleged suspects in the same courtroom, basically with competing narratives. And so it becomes an interesting question for the jury. Can they really apply a reasonable doubt standard and say, maybe Burch's guilt is a subject of reasonable doubt? Or are they basically confronted with the two suspects? They got to think one of them did it. And do they instead see their mission here as which one is guiltier? And so if it's 55-45 Burch, then you got to convict Burch, they might think, rather than let both people go, because they got to be strongly convinced that one of them did it, and it's a brutal murder. So very unusual dynamic in the sense that it's not just did this one do it, it's which of the two did it.
It is a different dynamic. Now, the evidence in this case seems like it could support or detract from a couple of different stories, because as the prosecutor argued, Burch's story doesn't add up when you look at some of the forensic evidence. For instance, the Fitbit data. The Fitbit data would indicate that the boyfriend, Dietrich, wasn't active around the time that authorities believed the murder was occurring. But we've got evidence that these Fitbits mess up every now and then. So can we trust it? Questions about that. Questions about whether Dietrich, the boyfriend, was making his own bizarre statements to police. He had said at one point that, the reason that the girlfriend, the victim, didn't come home was because she had bumped her head. That's what the boyfriend said to the babysitter. That doesn't make a lot of sense if he had indeed not seen her since she took off and went to another bar and then was fighting with him over text messages. So he's made these bizarre statements. We're not sure that the forensic data necessarily supports what this defendant is saying either. The jury's got a lot to weigh out here.
I think they do, and I think the babysitter's statement is especially critical because it's the one truly independent thing that seems to really discredit Dietrich. Other than that, a lot of the independent evidence, including the forensics, seems to be stacking up against Burch. As you said, you can challenge cell phone analysis. It's not perfect. It's not DNA 99%. Same thing with Fitbit. It's not a well-recognized technology. On the other hand, if we put ourselves in the juror's place, they don't want to let the brutal murder of this woman go unpunished. If they think they got to find somebody, it seems like it's stacking up a lot more against Burch than Dietrich, even though, as we talked about, the babysitter's testimony does seem very, very hard to explain. The other thing that's going to occur to one or more of the jurors is if Burch is guilty, this narrative he came up with does sound like a story that somebody looks back and says, okay, how do I explain the evidence? What do I come up with in order to somehow get off the hook when there's going to be evidence that I was involved in basically touching the body of the victim. So they certainly, as they sort through this thing, they've got a lot of things to struggle with. And at the end of the day, could they simply render a reasonable doubt verdict and say, we think it might have been Burch, but, we just are not convinced beyond a reasonable doubt that it was him as opposed to Dietrich. That's a hard thing, from a moral standpoint for a jury to do, but legally it's their duty. It'll be fascinating to see how this comes out.
There is no legal duty in most states to report an accident or report a crime. You don't have to pick up the phone and call 911. Certainly, morally, people think that they should, that's what they should do, but there's not a defined legal duty to do it. But in this case, the prosecutor really hammered at the defendant when he was on the witness stand saying, hey, look, why didn't you report this? Why didn't you call 911? Why didn't you go to the sheriff's department? Why instead did you just go fishing with your buddies after you were apparently involved in this big heinous act? So, I mean, do you think that the defense should have jumped in there a little bit more and said, hey, wait a minute, he doesn't have a legal duty to do that, so why are you trying to make it sound like that's what he should have done? Or is this just argument for the sake of cooking up a story?
They could have brought that out, but it's hard instinctively to say that somebody has this horrible, worst night of their lifetime experience, and then they're out fishing next day without any signs of injury and without any discussion. It may be that the defendant thought that trying to explain somehow why he didn't report this to anybody. Granted, there's no legal duty to report crime except, for example, in instances of child abuse, elder abuse, people that have responsibilities as caretakers, as caregivers, may have a duty to report crime, but generally not. The defense certainly could have made that point, maybe try to get a strong jury instruction on it, but it's also possible that they thought, look, that looks terrible. We've got to basically put Dietrich on trial. And the more we do to try to explain our own conduct, our own client's super bizarre action, the more we're fighting a losing battle.
Want to let our viewers know what's going on in the courtroom right now. The members of the jury apparently have a question. We do not know what the question is. Oftentimes, or I should say throughout the duration of this case, the judge has not allowed us to stream anything that is happening outside the presence of the jury. So right now, we can tell you, however, that the attorneys and the judge are gathered at a sidebar, presumably to discuss whether or not this question can be answered and how it should be answered. That's what's going on right now. We're anxiously waiting to see what this jury question might be. We will bring you a stream if they go into open session. If not, we'll continue to convey what's happening in the courtroom. So while we wait for this jury question, Attorney Coffey, I think that one key part of this case, the evidence, the key part of the evidence here, is what was going on between the boyfriend, Dietrich, and the victim in these really nasty, vulgar text messages that they were trading back and forth. Because this, as the story goes, they're out together at this bar, meaning the boyfriend and the victim. He starts hanging around with other friends, at least one or possibly several of whom were women. She gets very jealous. She gets upset. They had a young child together. They hadn't been out together in quite a while. The boyfriend even testified he couldn't remember their last date, okay? And she gets mad and takes off and goes to this other bar, and they're fighting back and forth with these really vulgar text messages. It was an explosive point of evidence in the beginning of the case. You know, you've got that environment going on, and then she disappears. I'm wondering if the defense really keyed in on that enough. You know, the prosecutor is sitting there in closing argument saying, none of this makes sense, meaning the defendant's story doesn't make sense about this, you know, going back to the house and having consensual sex. And the prosecutor just keeps saying it doesn't make sense. Well, the counter argument is it does make sense because she was upset at the boyfriend and may have wanted to spite him. But people seem to not really want to go there very much.
Well, I agree with you. That really should have been the drum that the defense pounded on. Obviously, the more they talk about Dietrich, the less they want to talk about maybe Burch. And, you know, just in human terms, does this kind of scenario where boyfriend, girlfriend, bitter, complex relationship, ugly, nasty exchange, They separate. Does it happen in our experience that, yeah, somebody ends up getting killed between the boyfriend and the girlfriend? It does. It's plausible to believe that, leaving aside the forensic evidence, and there are things that Burch has a lot of trouble with in this case, but fundamentally, the theory that Dietrich killed her is plausible. It's believable, and that's why, as we know, initially the police arrested Dietrich. Things turned around, but given the strength and the optics of what was going on between boyfriend and girlfriend, you would think that about 70% of the closing would have concentrated on that.
Yeah, I'm curious to know how this is being sorted out in the jury room. We know that there is a jury question being asked. Both sides, the prosecution and the defense, are sort of huddling about it, waiting to see if they go back in open court. In the meantime, let's continue our review of testimony from the defendant himself on the witness stand yesterday afternoon.
Were you specifically told to go around the back?
I was pretty much told to go in the driver's seat. I don't remember if I was told or if that's the direction I picked, but that's the way I went around.
And again, that's what you did?
Yes, sir.
And what did that other individual do at this point?
Stayed, like, so pretty much mirrored the way I was moving, and then came behind me after when I got in the driver's seat, and I believe I shut the door first. I don't recall though. He got in the passenger seat behind me and shut the door. But I do remember when I was getting in the driver's seat and I looked in the rear, I could see him in my peripheral, like over here, through the window. He wasn't in the vehicle yet, but he was in the process of getting ready to enter the vehicle.
Let me just make sure I heard you right. So you recall that you were seated in the front driver's seat, and through your peripheral, you could see him through the window, and he was still outside the vehicle?
Through the rear window. If I'm like the seats here, if I look like this, you can see the back window, and I could see him in that vicinity right there. He was only a couple feet away from me.
So what did you say happened after that?
Then he ended up getting in the vehicle and sitting behind me, but angled a little bit this way.
So again, I know you're using your hands.
Sorry.
No, it's fine. You're in the front driver's side. I'm sorry, you're in the driver's seat.
Yes, sir.
This other individual gets in the vehicle from the rear driver's door.
Yes, sir.
Before we keep going with that, the front driver's seat is, I guess, set. Let me rephrase that. The layout, or how that seat is positioned, is based on how it was when you were last driving the vehicle.
Yes, sir.
And how do you have that? How did you have that driver's seat positioned?
The rear back half of the seat was tilted back a little bit, and unfortunately, I have to drive. A lot of people like to get in and put the steering wheel down some, but with me, I have to put it up some, because if not, my legs rub the steering wheel as I'm trying to drive.
And that's how the seat was when you got into it?
Yes, sir.
Okay, now you said this other individual got into the vehicle and was not seated directly behind you?
Directly behind me, but off center just a little bit.
Some more of the defendant's testimony in the George Burch case out of Green Bay, Wisconsin. That defendant facing a possible life sentence if a jury, which is deliberating his fate right now, agrees that he is guilty of first-degree intentional homicide. What's interesting to me here, and Attorney Coffey, you tell me if you agree with this, is just the level of detail that this defendant goes into. So either he has spent an incredible amount of time trying to come up with these details, making them up, or this is the way it went down.
Well, and the more details, sometimes the deeper the hole you dig yourself into. If this was so vivid and he recollects everything in so much detail, he doesn't even talk about it the next day while he's fishing. It isn't so dramatically carved into his psyche that he makes no comment about it. I mean, it just strikes me, and of course, lawyers don't tell their defendants what makes the most sense in terms of what they're going to say on the stand. You're not supposed to do that. But it just strikes me that if you have this shattering, numbing experience, you're basically forced to dispose of the body of a murder victim at gunpoint. A normal person would be entitled to be sort of shaken up, not know every little thing, just have sort of basic impressions, basic facts. And to be describing things in so much detail, it really isn't necessary. It creates more, minds in the minefield that you can stumble into in terms of, quote, keeping your story straight. And at the same time, there's bound to be at least one juror that wonders, I can't remember what I was doing 3 months ago. Last week, I don't know what I had for lunch. Why is this person so meticulous in weaving this web of what happened that night? So, and you add to that the fact that he didn't report it if he knew all this, and it was so deeply embedded, so searing in his memory. There's going to be some skepticism about that for sure among the jurors.
Yeah, the amount of detail here has just been interesting, and what's interesting, and this again could be characterized one of two ways, is that the victim's body was ultimately dumped just up the road from where she lived with the boyfriend. Burch was a relative newcomer, so one could believe that he dumped the body nearby because he just didn't know where else to go, didn't recognize the area, wanted to dispose of it quickly. One could also argue that if it went down the way Burch said it did, that the reason that the spot was picked by the boyfriend is because he knew it was nearby and could make a getaway, which ultimately is what the defendant said the boyfriend ultimately did after he claims to have lunged at the guy. But you got to remember as well, Burch is 6'7". He's a pretty big guy. A lot of people laughed when he said on the witness stand yesterday that as this was transpiring, he lunged at Dietrich, the boyfriend, and then took off. But Burch is a big guy. I mean, he could potentially take a person of average stature or even above average stature.
And that's one of the, when you look at, as you go through fact by fact, issue by issue, is it Burch or is it Dietrich? That's another fact. Burch is the big guy. You've got a violent murder and, a apparently somewhat violent sexual encounter. Does that seem to fit Burch maybe a bit more? And with so many of these issues, you look at where the body was disposed of. Is that something that a local is going to do, or is a local going to, try to hide it somewhere? There's explanations on both sides, but if that becomes the tiebreaker, once again, I think it breaks the tie against Burch.
Yeah, another bizarre fact here, I think, too, the boyfriend said that the reason that the victim didn't come right home from the bars is because she was going to walk home. Well, look, I lived in Green Bay, Wisconsin for 3 years as a journalist in the mid-2000s. That walk would have been a 9-mile walk through the industrial area of Green Bay, where the paper mills are, across the river, through the city of De Pere, way out through some other residential neighborhoods into the very fringe of where the development hits the farm fields. That's a long walk for someone to try to make, so why did the boyfriend say that the victim was just going to walk all the way home like that?
I guess he wanted to have some explanation for why he didn't pay attention to her or why he wrote her off. But it's not a very good fact from the Dietrich standpoint. Somebody's going to walk 9 miles home. I don't care whether it's Wisconsin or beautiful South Florida. That's not credible. So whatever the jury thinks about Dietrich and thinks about Burch, they're not going to think that's truthful. Doesn't mean Dietrich's a murderer, though. And so that's kind of like some of the other statements Dietrich made to the babysitter. It suggests that this is a guy who was lying, who had some really nasty blow up with her and is trying to come up with things that somehow reduce the view that he might be the killer. After all, he was arrested. He was somebody who's very, very much afraid of being found to be guilty at the end of this. So he does lie about some things, you've got to believe. And if you were just looking at Dietrich, again, which should be the predominant focus of a defense strategy, then you look at boyfriend, girlfriend have kind of nasty blow up. They separate. Boyfriend unconvincingly says she was going to walk home. Really ugly texts exchanged between the two of them. Girlfriend winds up dead. Most of the time, that's a pretty incriminating set of facts. And it may be that if at least one of the jurors concludes that it's more likely Dietrich, based on those facts, somebody who doesn't really buy into the forensic and thinks that forensics get it wrong too, they get one holdout juror and it's a mistrial. And from a defense standpoint, that's often considered a win.
Yeah, we're going to go to another clip here of the defendant testifying on the stand, but I want to let everybody know what's happening in the courtroom, or I should say just happened. We were not able to stream this, but there was a question from the jury. There was a request for records from the DNA analysts. So the jury really wants to pore over those DNA records. The jury also has requested a number of other exhibits, which include GPS and GPS timestamps. So this jury really wants to roll up its collective sleeve and get into this hard data, which was presented on the witness stand. That's what the jury wanted. We will be back with more analysis of this case in just a moment.
To the right side, like right here a little bit, behind me to my, I guess that'd be 5 o'clock.
So not directly behind you, somewhat closer to the center of that back passenger seat, or back seat.
A little bit over, not center, but moved over a little bit, yes, sir.
What'd you do once you were in the vehicle?
Again, kind of tried to weigh what options I had at this point. It's completely kind of freaked out a little bit. Didn't know what was going to happen. Didn't have any idea what the situation that was going on was going to entail.
What options were you weighing at that point?
Still was running an option, trying to figure out what my options might be.
Did you have an opportunity to ever see this individual's face?
The first time that I saw the best physical image of this face was when I looked in my rearview mirror.
And when was that?
When I first started driving. Because once I started the vehicle, you have your interior lights, and the interior lights were bright enough that I could actually see someone. And I could see the reflection in the mirror, because I couldn't physically turn around and look at them.
And again, at that point, did you know who that individual was?
Never seen him before in my life.
Do you know who that individual is now?
Now I do.
Who was it?
It was that Dietrich.
So let's keep moving. You both get in the vehicle, and what happens next?
I was told to. I was parked on the right side of the street, and I was told to turn the vehicle around. So I don't recall if it was a Y turn or a U turn, but I turned the vehicle around and went in the opposite direction of what the vehicle was facing.
Did you have your seatbelt on?
No, I actually tried to put it on, and you've seen on movies before and things like that, and the only thing that come to my mind, the only option I had at that time was to wreck the car. And that's when I thought to reach for my seatbelt and put my seatbelt on, and then I was advised, don't even fucking think about it, don't touch it, when I reached up to grab it.
Were you in pain at this point?
I don't recall. It was more adrenaline pumping. I wouldn't say pain. I wasn't aware of it. I was more shaken and adrenaline just in the moment at the time.
Were you bleeding?
Not that I'm aware of, sir. I had blood on me, but I don't think it was mine.
So you turned the vehicle around?
Yes, sir.
So you were heading back towards the way you originally came from?
Yes, sir.
Keep walking us through that, George. What happened next?
I was driving, and while I was driving, I was told where to turn and which ways to go. I remember turning, I don't remember which direction we turned, but I want to say it was like a four-way, maybe a stop sign or something, and then I was told to turn it, I want to say it was left. Like I don't remember, to be completely honest. I just remember I was told directions on which way to go and where to turn.
What was what was Dietrich's demeanor like at this point?
Still behind me, still being forceful, telling me what to do. As far as I could tell, from what I could see from the glancing in the rearview mirror, he still had the firearm on me and was still sitting in that same direction behind me.
While you were driving, did he ever touch you with the firearm?
He nudged me. I can't say what it was that hit me. From what I've seen in his hands, I would believe that's what it was, right behind me on this side. But for certain, I can't say.
So he's telling you to turn whatever he's telling you. Go straight, go left, go right.
Yes, sir.
For the most part, were you on a paved street?
Yes, sir. Lined road, paved road.
Were you being given, I guess, strict directions?
Yes, sir.
It was deliberate, direct.
Right, telling me where to turn here. Yes, sir.
Eventually, did you leave the paved roads?
Yes, sir. We made a left turn onto service road, dirt road.
Were there any lights on that road?
Not that I recall, sir.
You said you turned left onto that,
If I'm not mistaken, I believe so.
and that road was not paved?
No, sir. It was. I remember. I want to say it was dirt. I don't think it was gravel. I think it was dirt, but it might have had some rocks in it. I remember it wasn't a paved area.
What's going through your mind at this point?
It's not looking good. I'm in the middle of somewhere. I don't know where I am. I have no idea overall what's going on. I don't know what's going to happen. I don't know what to do in this situation, and I'm trying to figure out the best way for me to remove myself from this situation, if at all possible.
Once you turned onto that dirt, maybe rocky road, did you continue to travel in a straight direction for a very long period?
I don't believe it was a long period. A couple of seconds, maybe a couple hundred feet, maybe, but it wasn't long.
Where did you go from
I was
there?
told to turn right.
And did you?
Yes, sir.
Could you observe any of your surroundings at that point?
It was mainly dark. I seen some trees, tall grass. I couldn't tell if it was a field or beginning of woods, or really couldn't tell exactly what it was. I know it was. It wasn't city or anything like that. It was a predominantly, grassy, tall trees and things like that area. I could hear crickets and things like that. I mean, that was about it, though.
Because your windows are down?
Yes, sir.
So again, you turned left onto the first non-paved road, then you turned right, and you just described your surroundings when you turned right. Did you keep traveling in that direction?
I was advised, or he had told me, it looked like it was a wooded area farther out. Because I couldn't definitely tell for sure because it was dark. But there was taller grass and everything. And I was advised when I turned in to go in and come back around like a big U pretty much. And when I came around, I was facing out in the direction of the way I came in, but just on like the farther side of the field or area.
So again, you turn left onto the non-paved road, you turn right, you can see what you think are woods up ahead, and as you're traveling in that direction, you then turn the vehicle around?
Right, I came in like this, turned around, and stopped like facing back towards the driveway that I came in.
Why'd you stop?
That's where I was told to stop at.
What happened after that?
I was instructed to turn the vehicle off, and pretty much he had exited the vehicle at the time and told me to get out the vehicle.
Do you remember who got out first?
He did.
Where'd he go when he got out?
Again, stood back, I guess. I guess it'd be more like 8, maybe 9 o'clock behind me. I was in the driver's seat and he was over to the side.
How far away?
It was more towards the back of the vehicle when I first got out.
Then after you were out, where was
He took a couple steps farther back.
So you did turn off the vehicle?
Yes, sir.
Did you take the keys with you?
No, sir.
So you step out of the vehicle, he's back at, I think you said 8 or 9 o'clock, takes a couple steps back when you get out of the vehicle. Then what happens?
I was told to pretty much reach in from the driver's side and grab Nicole and pretty much bring her out of the vehicle.
You said you did that from the driver's side?
I was in the driver's passenger, the back passenger side. You understand what I'm saying? Driver's side, back passenger.
Yes.
So I was leaned in, and she was, by this time, she had slumped over and was more like her top half was leaning towards the center of the back rear seat. It was like a bench seat.
So she was still mostly in the rear passenger seat where you had placed her before,
Yes, sir.
but she had become slumped over towards the center or the driver's side of the vehicle,
Yes, sir.
and you at that point removed her from the vehicle?
It was somewhat difficult, but yes.
And did you say you did that from the driver's side of the vehicle?
Yes.
So you had to reach from the driver's side over to the passenger side of the vehicle?
Right. The vehicle's not a huge vehicle, but I leaned in the back door and reached over, and it's on a couple feet to rigidly be able to grab her.
Why didn't you go around to the other side of the car?
That was where I was at, and that's where I was told to do it. How he explained, told me to grab her right then and there. The rear door was still open, so I just reached in and grabbed her. Because he was standing towards the rear of the vehicle,
He was towards the rear of the vehicle, but he wasn't right at the rear of the vehicle.
He was parallel to the vehicle. And I was up here, he was standing back here, I was up here reaching in the vehicle, and he was standing catty corner from me.
Did you, I guess, how did you get her out of the vehicle?
I had to pretty much grab her arms or under her arm area and pull her across the seat.
Was that somewhat difficult?
Yes, sir.
Why?
It's pretty much dead weight.
Were you eventually able to get her out of the vehicle?
It took me a moment, but yes.
And did you say that the way you grabbed her, did you reach into the vehicle and were you able to pick her up, or did you
Kind of pulled her to the edge, and then I put my arm under her again, and then kind of scooped, kind of carried her again with where she would be in my arms, I guess is the best way to describe it.
So going by your arm position there, it looks as though you're holding basically her entire body at one point,
Yes, sir.
with one arm, I guess, by her upper body, and then where would your other arm be?
Towards her like knee, thigh area, calf area.
What was Dietrich doing at this point?
He was standing behind me with he still had the firearm in his hands, pretty much directing me what to do.
And what was that?
He had backed up and he had told me to come down, and it's like I don't know if it'd be considered a ravine. It's not like really steep, but it's one form we call them a ditch, but I don't know like what you would call it here. But it's just like a little sloped area, and at the bottom there was tall grass, just a bunch of brush, shrubs, I guess, different types of wild growth.
Were you able to continue carrying her that whole time?
For the most part, it was kind of awkward because when you're carrying someone, and I guess they know it's a lot easier to control their weight. But at this point, it was kind of like everything was kind of loose and all over the place. So it was kind of hard. So I was kind of almost stumbling a little bit, trying to keep the balance of it.
Did her position in your arms eventually change?
Eventually, I had to, when I had turned around, I was looking at his direction. I couldn't hold her legs at the same time, so I ended up dropping her legs, but still holding I had my arms underneath her arms or armpit area.
So at some point, I think what you're saying is her feet are on the ground, but you're still holding her by her armpits?
Right, I'm holding her up, and her feet are more. If I'm standing this way, I dropped her feet, and she was kind of like we were at a little bit of an angle at I'd say the beginning, of where it starts to go down, just where the ground descends down.
You said at some point you're facing Dietrich?
Yes, sir.
What's going on at that point?
He was basically telling me to put her down and put her in that area, or place her in the area where I was, and he was instructing me on what to do.
So if her feet are on the ground as you described, and yet you still have to move her body, are you essentially dragging her?
When I had let her go, he had pretty much stopped, and I was at the area pretty much where I had been instructed to let her go at.
It was around that point in the defendant's testimony from the witness stand yesterday that the judge called a short afternoon break. Again, we're watching some clips from the George Burch first-degree intentional homicide case out of Green Bay, Wisconsin. The defendant facing a possible life sentence if he's convicted. The jury has the case right now. Attorney Kendall Coffey from Miami, Florida, remains on the line with us here at Law&Crime. One piece of testimony from that defendant yesterday, Attorney Coffey, was she felt just like dead weight. There was that dead weight phrase there, and it was one of those cringeworthy phrases. Because if that jury believes that this guy is the killer, it's the one thing that came out of his mouth that just didn't sound sympathetic at all. And even if he wasn't the killer, it didn't sound sympathetic at all that way either. And I'm wondering if that phrase might come back to haunt him.
Well, it might. It sounds so cold, and as I heard it again, I thought dead weight is used, kind of a lot by people who aren't killers. And yet, in this context, when he's describing what should have been so horrifying and shattering to anybody, he's at gunpoint, somebody he just met the night before is obviously brutally murdered, and he describes her as dead weight. Yikes. I'm sure that not only jurors cringe, but probably the defense lawyers too.
One would presume that his attorneys must have at least told him that he has to be sympathetic to the victim on the stand. I would at least presume that. I don't know if anybody picked any sympathy up for this victim really from the defendant or, frankly, from the boyfriend who was the father of her child. So neither of these two guys seem to really express much emotion about her unfortunate passing.
They don't. I don't think either of them came off as sympathetic themselves, and they certainly didn't seem to express sympathy to somebody who was brutally murdered. I mean, there are explanations for that. When you're a defendant in a murder case and you live through months, of course, especially if you're innocent, it's an ordeal for you, and it can be numbing. It can change people. It can change their personalities, and it can certainly change the way they recount the night of a brutal event. So there are human explanations for why somebody seems cold as ice when they're talking about such a horrible, human, tragic, brutal event. On the other hand, jurors generally are put off by that. And I can recall cases where people who were genuinely traumatized by a murder, because, for example, they happened to pull the trigger in an act of self-defense. Nevertheless, by the time they get on the stand many months later, sometimes even years later, they sound like a robot. And robots sound, by definition, cold and heartless, and seem much more capable of a murder than somebody who seems sad about it, who seems blown away by the gravity of that moment. It can be hard to recreate it on the witness stand many months later, but boy, it's sure a whole lot better in terms of jury dynamics if you can show some emotion and some feeling about the person who died.
Yeah, I say frequently that everyone reacts to situations differently and with different emotions. So, we have to keep that in mind, but to just stoically march through this, I think some members of the jury might be uncomfortable with. Another question here. We know that members of the jury within the last 20 minutes or so asked for records from the DNA analyst and also asked for exhibits with GPS data and with timestamps attached to that data. Can we read anything? Can we read the tea leaves to try to figure out exactly what the jury might be getting at here?
Well, we always try to, and a lot of times there are signals. Maybe most of the time there's some kind of a signal in jury questions. Of course, we're just speculating, but it's entirely possible, as you and I have discussed this case today, that the jury didn't fall in love with either of the two, and finds that they both were cold, unsympathetic and have questions about both. I mean, we can't forget the fact that Dietrich apparently told the babysitter, who we have no reason to disbelieve, she seems independent and neutral, that the victim was hit on the head and walked home. So that's not believable. And, you know, that kind of thing suggests that they're going to have questions about Dietrich, and there are plenty of questions about Burch. So is it possible that the jurors are deciding, look, we can't get to the truth by listening to either of these guys? And we've got to get to the truth with the forensics.
Well, even then, you know, is it possible that the forensics really tell the whole story here? We know that Burch basically admitted to going all the places where his cell phone data put him, so there's really not a conflict. He admits to being there. I guess the question is whether or not the Fitbit data or whether or not data about the boyfriend is going to back anything up.
Well, and that's how cases sometimes get decided on reasonable doubt. If the linchpin is forensic evidence, and it's DNA, or even strong fingerprint evidence, then obviously it goes one way. But is the Fitbit data, is that something that the jurors are going to be completely comfortable? Are they in the back of their minds going to say, well, I've heard about somebody who turned it off or didn't use it or manipulated it? And sometimes, heaven forbid, they look this stuff up tonight on the internet, which they're not supposed to do, but all kinds of crazy things happen during jury deliberations. So would they determine a person's fate based on Fitbit data and testimony? Hard to think so, but if it comes down to a very, very close call, and they think they've got to convict one of the defendants because they can't let this horrible crime go unpunished, then that could be one of the things that makes a difference. As you say, the cell phone data really isn't conclusive at all because it actually is consistent with Burch's narrative of what happened that night.
Well, that would be an interesting way to characterize that data. And look, presumably the jury is weighing over all of these issues now. It's an interesting case because ultimately the forensics, the Fitbit, the cell phone data might not tell the whole story here. Or I guess I could put it this way as well. They might not tell the whole story, and they largely are uncontested. We know that the victim's body had the defendant's DNA on it, but there's an explanation for that. It's a question of whether or not the jury believes it. So all of the forensics in the world, all the scientific steps in the world, they shed a little bit of light on this, but it's going to boil down to which of these two guys, if either of them, the jury believes. So it's going back to old-fashioned body language and judging the credibility of the witness who sits on the stand. This is pure confrontation clause stuff. It's why we have a confrontation clause. It's why we have 12 people sitting there and listening and weighing and judging the defendant's body language, the way he moves, the way he speaks. Is he credible? Do we judge him as a liar or do we judge him as an honest man? This is just the core stuff going all the way back to the beginnings of American jurisprudence. So we're going to continue listening to some of the defendant's testimony. We will be back with more analysis in a moment.
Thank you, Your Honor. George, we left off, I guess, when you were at the field that we now know as off Hoffman Avenue. So let's just pick up where we left off. Essentially, at some point you said you could no longer carry Nicole, and her legs, I guess, went down to the ground.
Yes, sir. Yes, sir. Sorry.
And at that point, you were then, I guess, pulling her by her armpits.
Like I said, I was pretty much in the vicinity of where I was told to go with her at the time. So when I dropped her, I didn't do much moving after that.
So you were on probation for theft of property.
Yes, sir.
And that played into why you didn't speak to the cops?
Yes, sir.
Well, what would have happened? I mean, what were you afraid of?
5 years in prison. At minimum. My suspended time was like I said, roughly about 5 years.
Why didn't you tell Ed?
I honestly don't. I don't know why I didn't say anything. I don't know if it was just where I'm from. You don't talk. You don't tell about things you've seen. You don't tell on people. People get killed all the time where I'm from for that. And I fear for my own safety if I would have ever said anything, because like I said, where I'm from, it happens all the time. People go to tell on people and tell things and they end up dead. They never make it to court. They never make it anywhere. They find them dead.
Did you follow this case on the news?
Yes, sir.
What did you learn from the news?
That the body had been found, and inevitably, or after the next couple of days, that Doug had been arrested.
You still didn't come forward with information?
No, sir. At that point, my reasoning was still somewhat the same, but in my opinion, they had the person that had done it. And I figured that they would see that and they would know that.
When did you learn that Doug was released?
I never did until I was arrested.
George, did you murder Nicole Vanderheiden?
No, sir. Definitely not.
Do you know who did?
Doug Dietrich.
I have no further questions. Thanks, George.
That was the defendant, George Burch, on the witness stand yesterday in his own first-degree intentional homicide case out of Wisconsin. Attorney Kendall Coffey from Miami, Florida, remains on the line with us. We were talking here in the studio, Attorney Coffey, about first-degree intentional homicide in Wisconsin is a lot different than the top murder charge in your state, Florida. From my perspective, it's relatively easy to get a conviction on it because the only thing the prosecution has to prove is basically that someone died and that the cause of death was homicide and that there was intent. There's no premeditation, and there aren't a lot of other elements that many other states would require in order to get a conviction on this. Can you compare the two?
You don't have a separate premeditation element, and a lot of outcomes can turn on premeditation. The one thing that's not an element in most states, not Wisconsin, not Florida, is motive. And yet it can be looming as a large issue that's not the subject necessarily of a jury instruction. The jury at some point in this case is going to wonder, where's the motive here? Yeah, I guess the theory would be with Burch that he was just some kind of brutish animal, homicidal, sexual assault or killer. But he doesn't really come off that way. I mean, he's a big guy, but there's nothing about his demeanor, about his past that suggests that he fits that horrific profile that we've obviously seen with some individuals. Angry boyfriend, angry girlfriend fight motive? Yeah, sometimes. And so I don't, motive is obviously not an issue. It's not an element of the crime in Wisconsin, but it's still something people think about because you think that people must have a motive for something this horrible. And if motive becomes an issue, even if it's not an element of the crime, you've got to think that could be one of the factors that tilts a little favorably toward Burch.
This brings up an interesting point of Wisconsin law that many people who followed the now famous Stephen Avery and Brendan Dassey cases know, and that is when pointing the finger at a third-party suspect, the defense has to prove means, motive, and opportunity. Those three things are required in Wisconsin law. They're three things that aren't even required of the prosecutor in pointing the finger at the defendant. But if the defendant wants to point the finger at a third person, the defendant's legally barred from doing so unless that third person fits that model of means, motive, and opportunity. A lot of people wonder, is that fair?
Well, it doesn't seem fair, and it's not consistent with the basic premise that it's for the prosecution to prove their case beyond a reasonable doubt. And the defense ought to be able to suggest other scenarios that point to a hypothesis of reasonable hypothesis of innocence. To burden a defendant's ability by putting any kind of evidentiary burden on a defendant doesn't seem fair to me, and I don't think it's a common feature. It's certainly not part of Florida law and the law of most states. Here, it appears that Burch can point to those factors. And of course, as we've talked about a number of times, what's so unusual about this case is both of the prime suspects are right in trial, testifying right in front of the jury. It's got to be one or the other, we think. How often does that happen? It's extraordinary, and it will be an extraordinary decision they make one way or the other.
As I was saying before, right before we lost you for a second there, this thing with all the forensics that we have available and all the scientific data, the Fitbit, this trial attracted a lot of attention because of the cell phone, because of the Fitbit, all of that. But look, as I was saying before, and you tell me if you think I'm wrong, this is going to boil down to none of that. It's going to boil down to whether or not the jury looks the defendant in the eye, looks the boyfriend in the eye, and which one of these two guys they believe. And it may boil down, or I think it will boil down to just that human interpersonal communication.
I think that's where it goes at the end with at least some jurors. But these things go in phases. And I think in their initial discussion, they probably said, gee, both of these folks seem to have questions about their credibility. As we've talked about, Dietrich pretty much caught in some lies. And yet he's not the one that's on trial. So I think the jury's initial reaction is that there's question marks about both of these. Let's go look at the forensics and see if we can get an answer there. They'll go through the forensic, and then I think, just as you suggest, when it comes back to it, look, they saw both of these people on the stand. They're the ones that are supposed to be able to look somebody in the eye, watch their body movement, watch all the things that you were talking about a little bit earlier in the show, and make a decision. And if they think at the end of this, there's a reasonable doubt, they're supposed to acquit, even if that means that perhaps the murderer whoever the murderer is, will go unpunished.
Well, that's the way it's supposed to go. But look, you've got a local jury here. You've got the boyfriend, who's a local guy, who's got political connections with the police. His family owns a business in the area that presumably some people may know about. And then you've got the defendant, who's the out-of-town guy. Might it just be easy for this jury to say, well, we got to punish somebody, and we don't like this out-of-town guy, and we just can't take the risk of somebody like him coming in here thinking they can get away with something. Maybe he was involved.
Well, the answer is certainly that's the easier way to go for this jury. And just to expand on that a little bit, do the jurors really want to go home to their neighbors, to their communities, and be a member of the jury that let this guy go and let this murder go unpunished? That's a lot to ask for jurors. They're sworn to do that kind of thing, but it's not always easy to perform that duty.
Yeah, we're going to continue reviewing this case. I want to pass along also the judge's ruling on the jury's request to have some DNA reports and some Fitbit records back in the deliberation room. The judge said that the DNA reports and the Fitbit records could not be sent to the jury for legal reasons, but however, the various pieces of tangible evidence, including the cords that were found on the side of the street near where the victim lived with the boyfriend, and some of the Google locations will be sent to the jury. That's kind of an interesting ruling. There must be some background behind it. I wasn't there to listen to all of it, and certainly I didn't hear the arguments for giving the jurors some things, but not all of the things that the jurors asked for. But that's the bottom line. That's how that ruling went out. We're going to go and listen now to the defense closing arguments in this case while we prepare to wrap up the day here on Law and Crime.